Holy cow, the Alec Baldwin case was slated to be the next trial of the century. But then it just imploded spectacularly, and Baldwin is now a free man. Our resident prosecutor, ScowlOwl, explains exactly what went down.
In a shocking decision, a New Mexico judge dismissed the manslaughter charges against Alec Baldwin for the death of cinematographer Halyna Hutchins on a movie set in 2021.
The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Your motion to dismiss with prejudice is granted.
How did we get here? During an explosive hearing on a motion to dismiss, the defense revealed that the state improperly withheld ammunition evidence from the defense, which violated Brady v. Maryland. Special Prosecutor Carrie Morrissey argued that the ammunition had no value as evidence because it wasn't the ammunition used on set, so the state had no ethical obligation to turn it over. But her co-counsel, Erlina Ocampo-Johnson, disagreed. She withdrew from the case when she discovered the undisclosed evidence. Johnson said she believed in the case against Baldwin, but that the state had a clear duty to follow the law.
Because remember, there are the SAG guidelines, there's bulletins, safety bulletins that dictate even if you're an actor, even if you're on a movie set, you treat a real firearm as though it's always loaded, never point it at another person, and don't put your finger on the trigger until you're ready to shoot. Those are cardinal firearm handling safety rules. So yes, did I believe that there was some inappropriate behavior with regard to handling this gun? I do. It's unfortunate that things went the way they went, but the fact of the matter is that we as prosecutors have very, very serious and high ethical obligations that when something comes to our attention, evidence comes to us, or we become aware of evidence, you turn it over.
What are the ethical duties of a prosecutor, and why did they lead to dismissal in this case? Today, I'll break down the judge's decision. Devin covered the basic facts of this case back in 2021. The short recap is that Alec Baldwin was the producer and star of a low-budget Western called Rust that was filming in New Mexico. The film had been beset by problems, with poor working conditions and some crew quitting halfway through the production. The lead armorer on the set, Hannah Gutierrez-Reed, was extremely green. On the day of the incident, Baldwin was preparing to shoot a scene where his character would cross-draw a Colt .45 revolver. When Baldwin was practicing the move, he pointed the revolver in the direction of cinematographer Halyna Hutchins, and the gun went off, killing Hutchins and wounding director Joel Souza. Baldwin claimed that he did not pull the trigger and that the revolver fired accidentally. IATSE and SAG standards do not permit live rounds on film sets. So how could this have happened? Strike one. The investigation got off to a slow start. The state charged Baldwin with involuntary manslaughter and a gun enhancement charge that would have carried a 5-year prison sentence. The first strike for prosecutors came when Baldwin's lawyers pointed out that the gun enhancement statute did not exist on the date of the shooting. The shooting happened in October of 2021, while the gun enhancement statute didn't take effect until May of 2022. Prosecutors dropped the charge, but didn't admit their mistake. Instead, they claimed that Baldwin's fancy lawyers were involved in some kind of voodoo trickery. But the error they made is obvious. It's something you learn in the first year of law school. A person can't be charged with something that was not a crime on the date when it happened. Fancy attorneys might even cite to Article 1, Section 10, Clause 1 of the United States Constitution, no state shall pass any ex post facto law. Then there were the problems testing the gun. The FBI was unable to get the revolver to fire. The only way they could make it fire was by hitting it with a mallet while the hammer was down. But then the gun broke during testing, and the defense couldn't independently test it. Meanwhile, the first set of prosecutors dropped out, and new special prosecutors Carrie Morrissey and Jason Lewis were appointed. They dropped the manslaughter charges against Baldwin because they needed more time to investigate. That was strike two against the state. The FBI started over, with ballistics experts using replacement parts to reassemble the gun fired by Baldwin. Experts concluded that for the gun to have fired, the trigger had to have been pulled or depressed. Finally, the state refiled manslaughter charges against Baldwin. Another special prosecutor, Erlinda Ocampo-Johnson, was added to the case. The state also charged armorer Gutierrez-Reed with manslaughter. A jury convicted her of involuntary manslaughter for loading the gun that killed Hutchins. The judge sentenced her to 18 months in prison. All of that set the stage for strike number 3, the Brady violation. In New Mexico, involuntary manslaughter consists of manslaughter committed in the commission of an unlawful act not amounting to felony, or in the commission of a lawful act which might produce death in an unlawful manner or without due caution and circumspection. The mens rea for involuntary manslaughter is that the defendant acted recklessly or negligently. The state's theory of the case was that Baldwin knew or should have known that Gutierrez Reed was young and inexperienced and that she might bring live ammunition to set. This was Reed's first job as an armorer. Special Prosecutor Johnson explained how she saw the evidence.
Based on my evaluation of the evidence that I was privy to and that I saw when I came on board on this case, was that there were numerous clips from the filming on the set that showed that Mr. Baldwin, unfortunately, did engage in some horseplay with this gun. For example, one individual who was interviewed by the OSHA investigators and testified or gave an interview that there was a time that he allowed Mr. Baldwin to use him kind of as a target. To shoot blanks at him, at his person. And obviously these are real guns. You don't do that with real guns. So there's
on a movie set? But isn't that exactly what they do on a movie set?
Well, no, you don't use another person as a target, as a human target. So that could potentially be reckless. And so, he wasn't charged with intentional homicide. There's no question, for me, there's no question Mr. Baldwin did not intend to do this. But the question is, was there wanton and recklessness? And so that's why I did believe in the case. I had no idea that this other evidence had not been turned over.
Now, obviously, if a prosecutor is trying to hide crucial evidence against you in your case, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've suffered a data breach, especially if you've got a data breach letter saying that your social security number was hacked, were involved in a car crash, or are dealing with an immigration issue, we can represent you or help find you the right attorney who can. It's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description or call the number that's on screen right now for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
Now, I don't think this was an easy case to prove, but the state's many false starts made a hard job even harder. It took investigators 15 months to charge Baldwin, in part because they had to do a lot of legwork to figure out how a live bullet found its way onto the set and into the gun. Before trial, the judge ruled that Baldwin's theory that the Santa Fe County Sheriff's Office's investigation was biased, improperly motivated, and incompetent was relevant and admissible. The legwork by police was at times sloppy. For example, defense attorney Alec grilled Santa Fe County crime scene technician Marissa Popple about the way investigators searched a warehouse owned by the company that supplied the production with guns and ammunition. During the search, Popple admitted that she was not sure if they collected every live round. In fact, she admitted that in order to determine if live rounds and dummy rounds had been commingled, she and her partner simply shook some of the boxes of ammunition to see if they rattled. And further, she agreed with the defense that this was exactly the same mistake that the armorer made on the Rust set.
And yet at the search being conducted to find the source of the lethal round, law enforcement is doing the very same thing that you're complaining about the armorer doing on the set, right?
Yes.
Robert Schilling, a former chief of the New Mexico State Police who worked as an investigator for the district attorney's office before being removed from the case, said this in an email to prosecutors that later became public. The conduct of the Santa Fe County Sheriff's Office during and after their initial investigation is reprehensible and unprofessional to a degree I still have no words for. The evidence against Baldwin came down to what he knew about Gutierrez Reed. His lawyers were looking for evidence that maybe the live round didn't even come from her. Maybe she was actually a great armorer, and the live round came from someone else. The defense had to poke holes in the prosecution's case. It all came to a head when Baldwin's team discovered that the state withheld evidence about additional live rounds that may have been on the Rust set. As outlined in the motion to dismiss, but the Santa Fe Sheriff's Office and the state have concealed from Baldwin that there was evidence that the live round that killed Hutchins came from Seth Kenney, a known person of interest and supplier of ammunition to the Rust set. Specifically, immediately after Gutierrez Reed's trial, Troy Teskey, a retired police officer and judge pro tempore in Mojave County, Arizona, delivered a collection of live ammunition to the Santa Fe Sheriff's Office where they were accepted by CST Marissa Popple. So if you've watched TV crime dramas, You'd think this evidence was immediately bagged and tagged, right? Well, not quite. The state had known about Teskey and his claim to have the rounds since 2021. Seth Kenney called Teskey during a November 1st, 2021 interview with then Detective Alexandria Hancock, after which Teskey sent a picture of a sampling of ammunition that did not match the rounds on set. That image was passed from Kenney to Hancock, and there was no further recorded follow-up. Teskey was a good friend of Hollywood armorer Thel Reed, who is Gutierrez Reed's father. Fast forward to 2023. In a November 2nd, 2023 pretrial interview of Teskey, the rounds were again discussed, this time with Special Prosecutor Morrissey. During the interview, Morrissey specifically asked if Teskey would give her the ammunition from the batch that Reed and Kenney had used to source their live ammunition for the Texas movie set. Teskey, who at the time did not know if the ammunition would match the round that killed Hutchins, agreed to provide it. And Morrissey closed out her interview, stating that she would work with law enforcement to collect it, the implication of which was that if she ever got the evidence, she would turn it over to Baldwin. However, Special Prosecutor Morrissey did not follow up, and neither did the state. Gutierrez Reed went to trial and was convicted. Afterward, Teskey took it upon himself to travel from Arizona to New Mexico, where he delivered the rounds to Popple. She took custody of the rounds and called her supervisor, Lieutenant Brian Brandel. They did not inventory the evidence to the Rust case. Instead, at Brandel's instruction, Popple was told to log it as documented information rather than physical evidence. And she was told to log it under a different case file so that it would never be disclosed to the defense. Teskey told Popple that among the rounds that SFSO took into its inventory and logged under a different case number are Starline brass casings with nickel primers matching the live bullet that killed Hutchins. So back to that disastrous cross of Popple. She confirmed the defense allegation that she documented the rounds under a different case number. Remember, the defense theory was that the state was trying to bury the evidence, and lo and behold, there's evidence that backs that theory up. When Spiro questioned Popple about her report, he pointed out a line which read, "It should be noted that this is not actual evidence collected in the death investigation." Both the witness and the defense lawyer agreed they'd never seen language like that in an evidentiary report. Popple said the line was added to the report by the lieutenant. She said, "My report says Mr. Teskey says this is related to Rust." That certainly makes it look like Lieutenant Brandel added language to downplay the relevance of the rounds. And then, as the defense pointed out, Popple put the report under another case number. Eventually, Special Prosecutor Morrissey started her redirect of Popple and wound up touching on the disputed rounds. When Morrissey asked Popple if she ever showed the prosecutors the rounds before this moment, Popple said no. Popple also confirmed that she never showed the prosecutors the report, which is also bad, very, very bad. At this point, the prosecution was in deep trouble, and they took a break for lunch. During that lunch, Erlinda Johnson confronted the other prosecutors about the evidence, which she didn't know about. Johnson wasn't involved in the charging decision and didn't sit on the 2021 interview with Teskey or the 2023 pretrial interview of Teskey. Here's how Johnson saw the situation.
So once I learned that this evidence was not turned over, that it was there, it was under a different case number, and my obligations, my ethical obligations as a prosecutor. Now, keep in mind, I've been a prosecutor. I was a state and federal prosecutor for over a decade. I've been a prosecutor. I've been a criminal defense lawyer for the last 16 years. So I've been on both sides. And I know what you're required to do. And when this came to light, I think that the best decision would have been for the state to dismiss the case. That's why I resigned.
Really?
Because I believed that that case should have been dismissed. And I advocated for that over the lunch hour, and it wasn't. And so when we came back after the lunch hour, I asked to withdraw.
When they came back to court, the judge agreed that Johnson could withdraw from the case. Morrissey then put herself on the stand in an attempt to convince the court not to dismiss the case. She said that back in 2021, she looked at the photograph of the Teskey rounds and determined that they were not at all similar to the live rounds used on the set of Rust, so I made the decision not to collect the rounds since they had never left Arizona. Although the state had discussions about collecting those rounds, they did not follow up. Under the Due Process Clause of the United States Constitution, the prosecution must turn over to a criminal defendant any significant evidence in its possession that suggests the defendant is not guilty. That was the ruling of Brady v. Maryland. In that case, a jury found two men, John Brady and Charles Boblet, guilty of first-degree murder. They were sentenced to death. During his trial, Brady took the stand and admitted that he participated in the robbery of the victim, but not in the killing. After he was convicted, Brady discovered that Boblet previously confessed to the murder, but the prosecution suppressed that evidence for Brady's trial. The Supreme Court held that the prosecution's suppression of evidence violated the Due Process Clause of the 14th Amendment. The suppression by the prosecution of evidence favorable to an accused upon request violates due process, where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. In Brady, the jury was empowered to restrict the punishment for first-degree murder from capital punishment to just life in prison. If Brady had known about Boblet's confession, it could have changed the jury's verdict as to the death penalty. New Mexico Rule of Criminal Procedure 5501A requires prosecutors to disclose all evidence against the defendant within 10 days of the arraignment, including any material evidence favorable to the defendant, which the state is required to produce under the Due Process Clause of the United States Constitution. The prosecutor has a continuing duty to disclose under Rule 5505B. If the state violates their obligations, the court is authorized to take a range of options, such as granting a continuance, holding an attorney in contempt of court, or dismissal. Prosecutors have a clear ethical obligation to disclose evidence which is material and exculpatory. For example, in Chacon v. State, the state of New Mexico negligently failed to disclose a supplemental police report and a witness statement which had been misfiled in the district attorney's office. These misfiled items were material to the preparation of the defense because they were material to the defendant's guilt or innocence. The prosecutors didn't deliberately or knowingly conceal the items, but that wasn't dispositive. The law requires the disclosure of exculpatory and impeachment evidence when such evidence is material. Special Prosecutor Morrissey argued that the disputed ammunition was not material because testing showed the rounds were not the ones that killed Hutchins, and therefore it wasn't important to Baldwin's defense. But her co-counsel, Erlinda Johnson, vehemently disagreed.
Why did you believe this ammunition was so important for the defense?
So obviously, you're a lawyer, I think. Brady versus Maryland imposes requirements on the prosecution to turn over evidence. The rules of criminal procedure impose those requirements, those duties as well. So is the evidence material? That's number one. How timely is the disclosure? Without question, this was grossly untimely. Number two, is it material? So the question is, could the defense have made some use of this evidence in their defense? And like I said, we as prosecutors do not get to make that decision what the defense is going to be. It's, can the defense use this and could it potentially raise some sort of reasonable doubt? And you have to step back. You're not an advocate. As a prosecutor, you're not an advocate. You are there to present the facts and to present the evidence. And your job is, and that's why I took this case on, I agreed to come on board, is because there was a woman who was killed, no question about it. This was tragic. And something happened, and a jury needed to make that decision.
The dispute between the two prosecutors came down to Morrissey believing that the state had the right to exclude evidence it later determined wasn't material, versus Johnson insisting that only the defense gets to make that call. First Judicial District Judge Mary Marlowe Summer sided with the defense, dismissing the case with prejudice. Ruling from the bench, Judge Sommer found the state culpable for willingly and deliberately trying to prejudice the defendant.
Case law is very clear that because it's very extreme, I have to go through every single element and I have to make a very good record as to why I'm seeing what I'm seeing. So in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense.
The judge said that suppression of evidence by the state does not require a finding of bad faith or any other culpable state of mind by the prosecutor. And she found that
this prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence.
Then she considered whether the evidence was favorable to the accused.
This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense.
In deciding whether the evidence is material, Judge Sommer considered whether the late tender of the evidence impeded the effective use of evidence in such a way that it impacted the fundamental fairness of the proceedings. She ruled that it did, because the exculpatory value of the evidence couldn't be analyzed at such a late date in the process.
The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins.
This is the key point. The state is saying, we now know which live rounds killed Hutchins, but the defense was deprived of the ability to test the weapon because it broke. The prosecution was aware of live rounds that may have been on the set, but withheld that information from the defense, meaning that the defense was deprived of the opportunity to examine and test the live rounds that were discovered back in 2021. Why did this warrant dismissal with prejudice? Because the state unilaterally withheld in bad faith, and access to the evidence was precluded by the state's intransigence. Back to you, Judge.
The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching.
Scorching. Ouch. You burnt. Given that finding, prosecutors in this case could face professional sanctions for their conduct. In an interview, Chris Cuomo asked Johnson if she should have just waited until the judge made a ruling to resign from the case. She said absolutely not.
No, absolutely not. I have ethical obligations. And personally, I have moral obligations. And my ethical obligation and my moral obligations really are not that different. And so when I see that something isn't right, and when I see that the law isn't followed, I don't care who you are, where you are, you make the right decision. And for me, the right decision was to walk up to the judge and ask to be allowed to withdraw before that circus of a hearing got underway.
So what happens next? State prosecutors could face disciplinary proceedings, and Gutierrez-Reed probably has a strong argument on appeal. After the Baldwin case was thrown out, her fancy lawyer, Jason Bowles, said that they would be moving for her immediate release. Oh, and a parting thought to prosecutors and aspiring prosecutors out there. 1, no case is worth your integrity or your bar card. 2, be more like Erlinda Johnson. And 3, it's okay to be a little fancy.
And right on cue, lawyers for Hannah Gutierrez filed an expedited motion in the Santa Fe First Judicial District Court of New Mexico for a new trial or dismissal of the case against her based on severe and ongoing discovery violations by the state. And on top of that, Baldwin's lawyers signaled their intention to sue the Santa Fe sheriff and prosecutor. So this is not the last we've heard of this case. But thanks to Spencer the ScowlOwl for that incredible analysis. He's a prosecuting state prosecutor and former JAG attorney and always brings incredible insights. And if you enjoyed Spencer's analysis, we've got a whole bunch of exclusives on today's sponsor, Nebula. For example, you can see our extended reaction of the film Primal Fear, Spencer's exclusive analysis of all of Steve Bannon's crimes, and the Nebula exclusive of Spencer's reaction to the movie Rules of Engagement. Because on Nebula, you can watch all of our videos ad-free and early. The videos always go up on Nebula first. Plus, there's tons of exclusive content, and for a limited time, you can get a lifetime membership. You can buy once and then never again. It's the greatest deal of all. And I know tens of thousands of you signed up for Nebula using the CuriosityStream bundle, but unfortunately, that is over. CuriosityStream has informed us, and included in their latest SEC filing, that they don't intend to pay us bundle revenue in 2024. This means that I and my fellow Nebula creators won't get any money for bundle subscribers. So the bundle is breaking, and you're not going to be able to access Nebula through CuriosityStream after 2024. So if you want to support this channel, the only way to ensure that the money you spend on Nebula goes directly to us is to sign up directly. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. With your favorites like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and of course, LegalEagle. And exclusives on Nebula are getting really good. I've really been enjoying Jetlag, the Getaway. It's kind of like The Amazing Race, but with some of my favorite YouTubers, and it's hilarious because the whole thing is rigged against them and they don't know it. And you can also see my feature-length documentary, Bad Law Words Good, and our other Nebula exclusive content, including a full-length interview with the screenwriter of My Cousin Vinny, and the Not Safe for Work video about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is that it's a creator-owned platform built by me and other YouTubers and podcasters. It's becoming the answer to the question, how do you get Hollywood-level production value without Hollywood-level BS? And for those of you that want to share everything it has to offer with your friends and family, Nebula now offers annual gift cards. Now, if you sign up using my link that's on screen right now, you can give a year of Nebula to a friend for 40% off the yearly subscription. And that friend can be you if you want. So you can get a 40% off discount for you or a friend's yearly subscription, or you can check out Lifetime, where for $300, you get access to Nebula forever, with your purchase going to fund the creation of even more exciting originals than ever before. In a way, Lifetime is the best possible deal of all. Either way, you'll get all my videos early, get access to exclusives, and support the ambitious projects that my friends and I are working on our own streaming site. So sign up now and get you or a friend 40% off of Nebula, or get the incredible Lifetime deal by clicking on the link below. And after that, click on this box over here for more Legal Eagle, or I'll see you in court.